The maxim injuria sine damno, as we have discussed, it means injury without damage. So, this injury can be to a person regarding his reputation or falling both assault or battery or nuisance or defamation, etc., and also to the body of a person regarding as such trespass to land or trespass to goods, and in that connection we have discussed already those leading cases as we versus White Souls of Him Singh versus State of Jammu Kashmir, and also Ashrafi Law versus the Municipal Board area, where the very statutory right was infringed of the plaintiff, for which the defendant was held liable. So the other maxim, that is damnum sine injuria, so it means damage without injury, and in that connection we have to discuss a leading case, Mughal Steamship Company versus MacGyver Go and Company, 1892, where it was held that the defendant company, as it was engaged in the same trade or business that of the plaintiff, even though there was certain damage to the plaintiff, but it did not cause any injury as it falls under trade competition. So, the very next maxim, that is the very important maxim, that is called volenti non fit injuria, and here it is exactly means harm suffered voluntarily, and in that connection we would discuss the leading case, Hall versus Bricklands Auto Racing Club of 1939. The King's Bench held that a person who is participating or witnessing the very auto racing, if any accident or damage is caused, then as he is participating or witnessing voluntarily, so any damage caused would not be held as injury. And the second leading case relating to that is Shadwell's versus Imperial Chemical Industries of 1964, where the House of Lords holds that as the plaintiff was sufficiently and very previously warned about the very stone quarry explosion as a detonator was fixed by the defendant for the stone quarry, and all statutory methods were taken and all necessary steps were taken by the defendant, and as it was informed to all previously, so here it was held that the very plaintiff did it is voluntarily, so the defendant was held not liable. So in another leading case, that is Ulrich versus Summer in 1968, the Queen's Bench held that as there was a horse racing and a photographer enter inside the horse racing to take photographs of the horse race, then the act is voluntarily done by the plaintiff, so any damage or injury caused to the plaintiff would be held under this maxim, voluntarily non-fit injuria. And another one is that Act of God. And under Act of God, we would like to discuss a leading case, that is Blythe versus Birmingham Water Works Company 1856 of the King's Bench. In spite of taking every statutory precautions and all necessary steps, the very water pipes let down by the Birmingham Water Works were burst due to severe frost in the area, so it falls under Act of God, so the defendant was not held liable. So in another leading case, Nicholas versus Marsland in 1875, the House of Lords held that all the water pipes that were let down were burst, and it was again, in spite of taking all the measures by the defendant, the artificial tanks made by the plaintiff were fed by natural streams, but as there was heavy rainfall, so water escapes and those artificial tanks were broken. And in spite of taking all statutory precautions and all necessary steps, as the water escapes from those artificial lakes and it was due to heavy rainfall, so it falls under Act of God, so the defendant was held not liable. And another reason of voluntary non-fit injury, and where the defendant was not held liable, and that is inevitable accident. So in regard to that, we will discuss the very leading case, Brown versus Candle of 1859, and the very Court of Appeal decided regarding the very facts of the case that both the dogs of the plaintiff and the defendant were fighting, and the defendant went to stop the fighting of the dogs by taking a stick in his hand, and that very stick, inevitably without the very knowledge of the defendant, it caused harm to the very eyes of the plaintiff. So this is held that it falls under inevitable accident, so the defendant was not liable. And in another most important leading case, that is Holmes versus Mather in 1875, House of Lords held that in the very fact, regarding the very fact of the case, runaway horses, they cause certain damage to Mather. The plaintiff filed a suit against Mather that his horses caused harm or injury, but as he took precaution and every necessary measures to stop the horses, in spite of that they crossed the boundary of his house and they caused damage to the plaintiff, and as it was not under his control, in spite of every attempt he took, so it falls under inevitable accident, so the defendant was held not liable. And another was the part of not to held liability under any act. It falls under necessity, and regarding that we will discuss most important leading case, and that is Grevenstein versus Hetting of 1911, where it was held that the very fact of case is that the defendant swept away from his field a swarm of locusts, and those they caused certain damage to the crops of the plaintiff. So here the very act of the defendant was not held liable, as he was not intentionally fled away all those swarm of locusts from his field, which ultimately caused damage to the crops of the plaintiff. So, in connection to that, we will discuss another most important leading case, that is Southport Corporation versus ISO Petroleum Company Limited of 1945, and the very decision was delivered by the King's Bench, and ISO Petroleum Company Limited as established an petroleum refinery in the area and took all statutory precautions and all necessary steps. In spite of that, it caused some damage to the Southport Corporation, and it was held that it falls under necessity. The very acts of the defendant company, Issue Petroleum Company Limited, show here the defendant was not held liable. And another one is that private defense, and regarding that we will discuss the leading case Turner versus Jagmohan Singh, and it was a case of 1905, and here the Allahabad High Court held the defendant was not liable, as the fact to the case, this vicious stallion of the plaintiff regularly they caused damage or injury to the mares of the defendant, and in spite of several warnings, the plaintiff did not take necessary steps to keep in control his vicious stallions. So ultimately the defendant caused certain harm or injury to the vicious stallion, which caused regular harm to his mares. So, due to the very act of the defendant, by inflicting injury to the vicious stallion, those vicious stallions ultimately died, and here it was held that in the very act of the defendant, it falls under private defense, so the defendant was not held liable. And in our upcoming video, we will discuss regarding vicarious liability, strict liability, and absolute liability.